have the right to remain silent. You have the right to have an attorney present during questioning. Ernesto Miranda didn't know that. Unlike Dolly Mapp, he didn't know his rights. Miranda was arrested based on circumstantial evidence linking him to a rape. The police interrogated him for 2 hours without telling him he didn't have to answer their questions and could ask to see a lawyer. In the end, he confessed. This confession was used as evidence against him, and he was convicted. Were his rights violated? The Fifth Amendment says that no person can be compelled to be a witness against himself. That clearly means that police can't force a confession out of you and then use it at your trial. But what happened with Miranda? Well, if these are all the facts you know, it's hard to say. Especially in the 1960s, before police routinely videotaped interrogations. A judge would know how long a defendant was interrogated, maybe, and some of what was said, maybe, but it would be pretty hard to figure out what the defendant's state of mind was. That's one thing the Supreme Court was worried about. Maybe we can't tell if a confession has been coerced. The other thing they were worried about was the psychological pressure on a suspect during interrogation. Someone who's in custody, who can't leave the interrogation room, and who has the police telling him that they know he did it, and now's his one chance to tell his side of the story, is subject to at least some degree of psychological pressure. Maybe for some people that overpowers their will, if the police do it long enough. In one of the cases decided along with Miranda, the interrogation lasted 5 days. And maybe for others it doesn't. Requiring the Miranda warnings solves both these problems. If you tell someone he has the right to remain silent, the right to see a lawyer, then you can be pretty sure that if he talks afterwards, he's doing so voluntarily. So that's what Miranda does. It makes sure that confessions aren't coerced, and also that judges can tell they aren't coerced. It's just as important to understand what Miranda doesn't do. It doesn't create the right to remain silent. That's in the Fifth Amendment, as I said. It doesn't create the right to a lawyer either. That's in the Sixth Amendment. What Miranda does is require police to tell you about these rights. If they don't, then they can't later use anything you say against you in, as the warning puts it, a court of law. Ernesto Miranda's confession was excluded then, but he was actually convicted anyway, without that evidence. Now let's try to think a bit about whether Miranda is a good decision. My aim here, as it was with the exclusionary rule, is not to convince you of a particular position, but rather to show you the arguments on each side. One thing to say in Miranda's favor is that it probably is good for people to know their rights. You certainly could argue that we shouldn't have certain rights, that they're a bad idea. Maybe people should have to answer police questions. Maybe they shouldn't be allowed to see lawyers. But those rights are clearly in the Constitution. If we think they're a bad idea, we need to amend the Constitution to get rid of them. It's harder, I think, to argue that we should try to get rid of these rights without amending the Constitution just by hoping that people don't know enough to invoke them. But does Miranda maybe have some of the same strange features as the exclusionary rule? The exclusionary rule is a little odd, remember, because it really works mainly to protect the guilty. It benefits the innocent only indirectly. Is Miranda like that? Who does it protect? One answer is, it protects the guilty. The innocent, after all, have nothing to hide. They don't lose anything by talking to police. But that's not necessarily true. People do make false confessions. And this is something that doesn't happen with the Fourth Amendment. People don't manufacture false evidence and put it in their houses. So Miranda benefits people who might otherwise get pushed into a false confession. And those people are innocent. In terms of who it benefits, Miranda is slightly less problematic than the exclusionary rule. But saying that something is sensible, or that it's good policy, isn't the same thing as saying it's part of the Constitution. And certainly, the Miranda warnings themselves aren't in the Constitution. So you might wonder where judges get the power to require them. Miranda is an example of the Supreme Court being pretty aggressive in terms of managing the conduct of law enforcement. So it seems as though Miranda is here to stay, which some people still don't like. But let me suggest a way of looking at Miranda that might make it easier for opponents to accept. Miranda, remember, doesn't really create new rights. It just makes sure that people know about rights they already have. It makes sure that those rights are available to everyone. And from this perspective, Miranda is really a decision that's based on equality, which is one of the themes that the Supreme Court pursued under the leadership of Earl Warren. Constitutional rights aren't just for white people, the Warren Court said. They aren't just for men. They aren't just for the rich. And Miranda is another step in that same direction. Miranda says that rights aren't just for people who know about them already.